Hello everyone and welcome back to our channel. My name is Malescu and I am a Florida Bar Board certified attorney and owner of Malescu Law, a law firm based in Miami, Florida, specializing in business, corporate and US immigration. We can assist you with all your immigration needs regardless of where you are currently located or where you plan to go in the United States. Today we are going to speak about one of our recent success stories, an E-2 essential employee approval. But before we get started, please subscribe to our channel by clicking the bell button or the subscribe button. We recently achieved a successful outcome for a US company owned by a UK investor, so a E-2 enterprise, seeking an E-2 essential employee visa for a UK national. Despite the complexities of this case, the United States Citizenship and Immigration Services approved the E-2 essential employee application for 2 years, the maximum period allowed. But also in this case, it issued a request for further evidence. The overall processing time, including the answer to the request for further evidence, was 2 months with premium processing. And now we are going to further discuss the key highlights of this case. The key challenges and solutions in this case were: 1. Aging out dependent. In this case, the essential employee was in fact the child of the E-2 treaty investor, approaching their 21st birthday and making their eligibility very complex for the E-2 essential employee status. Now, the child of the treaty investor sought to change status from E-2 dependent to E-2 essential employee through the United States Citizenship and Immigration Services. The case was filed while the child was still in E-2 dependent status, a status that is dependent on their parent E-2 treaty status. The child of E-2 treaty investor can apply for an E-2 employee visa to work at their parents' E-2 enterprise or to work for another E-2 company that is owned by a citizen from the same treaty country. Of course, this option where you have a child of an E-2 treaty investor applying for an E-2 employee visa are just one of the options that an investor can use with their children that are aging out. But a child could also apply for an E-2 treaty investor visa in their own right and not necessarily work for their parents' business or another E-2 company where the owner has the same citizenship as them. However, if you want to learn more about the option for aging out children on E-2 dependent visas, then you can visit our blog and you can go over one of our blog posts with all the options that are available. But in this specific case, the child of the E-2 treaty investor went ahead and changed status to an E-2 essential employee to work for their parents' E-2 enterprise. The solution we provided was to strategically position the child as an essential employee and highlight the experience abroad that the child had with the E-2 enterprise, but also their qualification within the E-2 enterprise. 2. Limited education and experience. The applicant, due to their young age, had limited qualifications. So our solution was to meticulously highlight the contributions that the applicant had to the business, but also the unique skills and knowledge that the applicant accumulated over time and were essential to the US business, to the E-2 enterprise. 3. USCIS scrutiny. The United States Citizenship and Immigration Services closely examined the employment relationship in this case and the applicant's qualifications for this position, and even issued a request for further evidence asking for additional documents to prove the applicant's special qualification, expertise, and aptitudes, but also the duration for which these essential skills are needed by the E-2 enterprise. We were able to establish from the beginning of this case that the E-2 enterprise indeed needed an employee with special qualifications, but the United States Citizenship and Immigration Services wanted to see more documentation that the applicant indeed had the special aptitudes and skills for this position, and also the duration for which these essential skills will be needed by the E-2 enterprise. To address this, we provided comprehensive documents in our answer to the request for further evidence to prove that the applicant indeed had the special skills, the essential skills that are needed by the E-2 enterprise, and also that their role is indispensable for the company. Ultimately, the change of status from E-2 dependent to E-2 essential employee was approved by the United States Citizenship and Immigration Services for 2 years, the maximum period allowed. So it ultimately was a success story, and we are very happy about that. But this was a very complex and challenging case to prove and obtain an approval for an E-2 essential employee. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.